behind-the-scenes meetings on how to handle the situation. For a time, it seemed that there was a Mexican standoff in Maguindanao. The Ampatuans handed over Andal Ampatuan Jr., widely suspected of being at the scene of the massacre, but the rest of the clan holed up in their mansions, and the government began being hammered domestically and internationally for appearing to treat the clan with kid gloves. Finally, last Saturday, Executive Secretary Ermita announced the President had imposed martial law and suspended the writ. Proclamation 1959 will go down in history as the first post-EDSA imposition of martial law, the first under the present Constitution, the first by a woman president, and the first to be marred by a typographical error. It mentions Republic Act 6986 as one of its bases in law, when that's a law UP Law Dean Marvic Leonen pointed out creates a public high school. Justice Secretary De Venadera later explained that they actually meant to refer to the revised penal code. Oops. So we'll now proceed to explore the legal basis for imposing martial law, because much of the talk going on now involves not only whether the President has made an adequate case for martial law, but what she can do with it while Congress debates it and the Supreme Court deliberates on it. Article 7, the Executive Department, Section 18 of the Constitution spells out the steps for imposing martial law. A president has some options when confronted with a challenge to government authority. First, when there is lawless violence, invasion, or rebellion, the president can call out the armed forces to suppress either of the three events. If the president feels this isn't enough, then there are two added instruments the president can use: martial law or the suspension of the privilege of the writ of habeas corpus. But they can be imposed only upon the existence of two simultaneous conditions: when there is invasion or rebellion, and when the public safety requires it. But there's an expiration date. Martial law or the suspension of the writ are only valid for a period of 60 days. Earlier, we looked at what the suspension of the writ of habeas corpus is. Martial law doesn't automatically include suspending the writ anymore. A president has to specify a suspension if included with martial law, or suspend even without martial law. So now let's look at the grounds for suspending the writ of habeas corpus. It's when there is invasion or rebellion, and when the public safety requires it. In any case, the suspension of the writ applies only to persons judicially charged with rebellion, or offenses inherent to rebellion, or offenses directly connected with invasion. And unlike the hook-busting days of Magsaysay, when the writ is suspended, it means government could suspend people for a long time back then while preparing their case. Today, the suspension of the writ is now limited in its duration. Any person arrested or detained has to be judicially charged within 3 days. Otherwise, he must be released. Now, unlike the days of Marcos, the president is answerable to the other branches of government for imposing martial law. The primary duty of the president is this: within 48 hours from proclaiming martial law or suspending the writ of habeas corpus, the president has to submit a report in person or in writing to Congress. Close to 10 p.m. Sunday night, or 48 hours, give or take an hour, after she signed Proclamation 1959, Executive Secretary Ermita submitted a 20-page report, 7 pages of which were photos, 4 pages of introductory text, 6 pages summarizing the massacre, leaving 8 pages justifying an imminent and not actual rebellion. So this brings us to the oversight role of Congress. The Constitution orders Congress to convene without need of a call or summons within 24 hours of proclamation or suspension. Now, since Congress was in session, our energetic lawmakers decided to take their time and not meet until today, or 72 hours after martial law is declared. After the President submits her report within 48 hours of the proclamation, Congress, voting jointly and by a majority vote of all its members, House and Senate combined, may revoke the proclamation or suspension. Now, this revocation cannot be set aside by the President. On the other hand, if the President can justify the proclamation or the suspension, and if the conditions of invasion or rebellion persist and the public safety continues to require it, the President may ask the period to be extended as determined by Congress. This is what Congress is set out to do tomorrow at 4 p.m., the very first time Congress will exercise this duty under the present Constitution. Which brings us to the role of the Supreme Court, which had disgraced itself the last time martial law was proclaimed. The Supreme Court may review in an appropriate proceeding filed by any citizen the sufficiency of the factual basis for the proclamation or suspension. Now, this deprives the Supreme Court of the option to chicken out. Now, the decision must be promulgated within 30 days of its filing. This means the Supreme Court can't drag its feet either. And because Marcos made himself not only president for life, but lawmaker and head of a system of military courts, today martial law prohibits a lot of things. It does not suspend the Constitution. It does not supplant or supersede the functioning of the civil courts or national or local legislatures. It does not confer jurisdiction on military courts and agencies over civilians when or where civil courts are able to function. And it does not automatically suspend the privilege of the writ of habeas corpus, as we saw earlier. So the President and her people have crossed the constitutional line in the hope that they can prove to the public martial law isn't merely not a big deal, but actually a pretty good deal in Maguindanao. The AFP has even proposed extending it to Election Day. And the President's report ends by saying martial law will be in place for as long as the President believes it's necessary. So the ball is now in the hands of the House of Representatives. Speaker Nograles at first said he didn't think martial law was necessary, but now says it's such a good thing he doesn't think Congress should even meet about it. Nevertheless, the House held a caucus this afternoon to discuss what to do about this. After all, the one and only time in the Constitution that the House gets to vote with the Senate, making it not a co-equal chamber, but the biggest block in a joint vote happens in this situation. And Juan Ponce Enrile held a caucus this afternoon too, with senators who were surely keenly interested in what this former martial law administrator has to say. The Senate, however, is handicapped in a joint vote on martial law because, oddly enough, the drafters of the 1987 Charter assumed congressmen would be more loyal to democracy than senators. Yet, as in 1972, opposition to martial law has been the most vocal in the Senate and not the House. So when we return, we'll meet a presidential candidate spokesman who also happens to teach constitutional law, his hopefully unbiased opinion on how Congress and the courts will handle martial law when we return.